may be seated. All right, next is, if I may. That's quite all right. Let me get settled for just a moment here. The court is calling Roy versus Dackman, and that is number 6. Good morning.
Good morning, Your Honors. May it please the court. Scott Nevin on behalf of the petitioner. I want to thank you for taking this case up for consideration, where the trial court abused its discretion by excluding the petitioner's board-certified pediatrician with 20 years' experience in childhood lead poisoning case. The mere fact that a person offered as an expert witness has not been personally involved in the activity about which he is to testify does not, as such, destroy his competency as an expert. That was the Wantz decision, citing this court's decision in the Radman case. At no time has the statutory law or this court ever restricted such speciality of a medical expert as ruled by the Court of Special Appeals in this case or in the Hazelwood decision. These decisions upended the case law, and the collateral damage in other fields of science and litigation is just waiting in the wings. So what this court is facing by taking this case is, are you going to reiterate what the case law is with medical experts and the acceptance based on qualifications, or are you going to change the law?
Well, what's the impact of Blackwell? Because Blackwell versus Wyeth, we did not, of course, the trial judge below did not accept the experts as experts, the experts that were proffered as experts.
Sure.
And we did, according to what you just said, change the law, but it is the law, that, and we said specifically that when complex medical issues or diagnoses are in question, we have required a specificity of knowledge, skill, experience, training, or education for qualification.
Sure.
So I don't think it's as black and white as you were just saying. I mean,
to a certain
Blackwell
degree,
has been our case law since 2009.
Sure. Well, to distinguish the Blackwell v. Wyeth case, that was a case where the allegation was thimerosal caused autism. And the individual who was testifying was basing that on his own research, and there really wasn't significant literature to support his findings. Well, and then there was a question of whether it was generally accepted in the scientific community.
Yes, but we specifically said with respect to the experts that have been proffered that the relevant, and this was Judge Berger when he was on the circuit court made the findings that epidemiology was the expertise that would have established, and none of these people, there was more than one, there were a number of them that were not qualified. And we were specific about that.
So let's take the 6 decades of research by teams of pediatricians, psychologists, neuropsychologists, public health officials who have researched childhood lead poisoning, published, and the Center for Disease Control has been issuing policy statements over the years since the early 70s on childhood lead poisoning about the sources of exposure, where children are being exposed, and the injuries that are associated with that.
So I understand what you're saying is that as long as there's a lot of literature, it doesn't matter about experience with the specific issue.
Well, I would believe that it, to a certain degree. For instance, are you saying, any board-certified pediatrician would be an expert in childhood lead poisoning case?
I'm asking
would that be the question?
This is your argument, not mine.
No, I understand that. But I would say in most circumstances, yes, because this fits within the mandate. There are mandates for pediatricians that they must follow and know about childhood lead poisoning, okay? But if you take a pediatrician...
So just let me understand. What you're saying is if a physician's board certification requires that he or she have some knowledge of an area, such as lead poisoning, and there's a large body of information available about lead poisoning, that's sufficient absent experience.
If that expert is aware of that literature and keeps abreast of that literature, yes.
Okay, so it doesn't matter whether there's whether the person's had hands-on experience.
And has to consider childhood lead poisoning on a routine daily basis, such as Dr. Sundell. My example
When
to
you
Your
said,
Honor.
I don't understand what you just said.
Okay. My example. If you're a general board-certified pediatrician in Goshen, Indiana, small town just east of South Bend. If you've never been there, you should pay a visit. It's a nice place. But they may not have lead in their community, lead paint in their community. And a pediatrician of 20 years may have never had to really address it and doesn't really care about it. It doesn't show up, okay? That individual might not be an expert in childhood lead poisoning. But you take Dr. Sundell, who was trained and has some training at Sinai Hospital in Baltimore City, Johns Hopkins Hospital in Baltimore City, currently has been working just a few miles away from Baltimore City. You bet he better be aware of the potential causes of lead poisoning and the injuries, because it's something he considers on a daily basis, and that's what the record reflected.
I understand everything you're saying to me. But I'm just trying to get, because we give direction to the circuit courts.
Sure.
Okay.
Mr.
You know,
Dackman,
so
I'm
go ahead. No.
I would like to ask if you have any comment to make with respect to what is footnote 4 in the respondent's brief, in which they state that they received Dr. Sundell's opinion something like 10 months before Dr. Sundell ever heard of this case.
Okay. That goes to a discussion back in the Hazelwood case, where there were many attacks on, I believe, a court that's not familiar with private practice, with putting up experts and things like that. I've been doing childhood lead poisoning cases for over 23 years. I think it is reasonable to state that I can designate an expert in what they anticipate to testify even before they see the case. I'm not saying that that's how they will testify.
How can you do that before you know what the expert's opinion is going to be?
Because I'm familiar with the facts of the case. I'm familiar with the literature. I'm familiar with the law as it stands.
So you're a quasi-expert?
After 23 years, I think I could answer most of the questions in a deposition. Yes, I could.
The implication, more than the implication, the statement in the footnote, if it is indeed correct, is that they received Dr. Sundell's opinion before Dr. Sundell could have ever had one.
That's not correct, Your Honor. What they received was a designation of anticipated opinions of the expert. It's our designation that we use in all of our lead paint cases that I've been doing for 20-some years.
Was it just a designation, I'm going to use Dr. Sundell as an expert, or was it an opinion of Dr. Sundell saying what he was going to testify to?
It's not only listing Dr. Sundell, but we also list other medical experts at the same time.
I'm talking about what's in footnote 4.
I understand that, and I'm addressing that. We provide a general designation that has, because at the point in which that designation is usually turned over to the other side, we haven't even given the records to our medical expert. It could have been Sundell in this case. It could have been another expert in this case. A lot of it has to do with availability. I'm sorry, I participate in a high-volume lead paint practice in Baltimore City. Unfortunately, there's a lot of these cases, unfortunately for my clients. So at the point in which we have to designate expert, and it says provide anticipated opinions of the experts. And we give the same scenario for each and every expert, that we anticipate that the expert will state that the child was exposed at the subject. We anticipate that they will be exposed, that they will sustain an injury. But it's not until the expert provides a report, which we do they actually get the opinions. And if the expert has a different opinion, which has happened in the past, the case tends to go away. And you don't see those. So I don't see where that's a violation or that it in some way impugns Dr. Sundell, because plaintiffs designate their experts before, because with the uniqueness
of... What it suggests as worded, and this is why I was just asking for your comment.
Sure.
It suggests as worded that he reached a conclusion an opinion
No.
before he knew anything about the case
Right.
that this plaintiff had lead paint poisoning
Right.
from this property, and it was that exposure that caused these damages.
It's very clear that, we didn't hire 6 medical experts in this particular case, but we designated them. Because the way this lead paint cases work is first you have to evaluate them by a neuropsychologist. We have to collect all the records, medical records. There's usually depositions of the mother and the child or another parent or guardian, and all that information is then provided to the medical. We have an 18-month scheduling order lead paint cases. It's not fast track. So it's not something that we have to have all together. There's no requirement all together before we file the lawsuit. So that, and also the fact that it comes up often that the expert only receives records from the plaintiff. I'm not sure what that means. In litigation, the defense gives their expert records, the plaintiff gives their expert records. What does it mean? And the court in Hazelwood found that offensive somehow, that the expert only has records provided by the plaintiff. Sometimes the records we give our expert, we got from the defendant. But does that mean it came from the plaintiff? Because we provide business records if there are any, leases if there aren't any. My clients don't have the leases. So there were a lot of comments that lead to me. There were blinders on in the Hazelwood decision when it came down to, because the law still says that the expert does not have to actually participate in that activity to become an expert. In fact, the cases that we cited, the distinction in our brief, the cases of Deese versus State, Samsung Corporation, where the orthopedist talked about erectile dysfunction in 2003, the Wantz versus the AFSO case, where there were 3 experts excluded, but then it was reversed. They were found to qualify to testify about things that were not particularly in their field. And then Nance versus Gordon in 2013, which was a nephritis case where the expert was not a board certified in nephrology. The interesting distinction is that with these cases where they're medical experts, they weren't testifying even about a procedure or an injury within their board certification. Where I have a board certified...
Did they have experience in those fields?
Some really didn't. They had a knowledge about it. They had the same kind of book knowledge, hearing about it professionally, but they didn't actually do the procedure. Okay? So here you have a board certified...
Which of those cases is the best case in terms of the level of knowledge that the expert had in the field?
I can't,
Best
I'm
case
sorry.
for you.
I'm going to be honest. I can't answer that analysis, right, which is the best. But it's been consistent. The Court of Special Appeals has consistently held it. Let's do the reverse. In 1997, I attacked Dr. Charnash, a defense neurologist in the Davis versus Goodwin. He had 0 experience in testing children, screening children, educating the parents on where children are exposed to lead. 0. I took it up on appeal. They allowed him to testify that my client wasn't exposed at a certain property. The Court of Special Appeals says he could testify as to that. Now, how is that possible? He had 0 experience. Where Dr. Sundell, with his 20 years of experience, working just south of Baltimore, every day has to consider, the possibility. Is it gasoline? Is it carbon monoxide? Is it household cleaners? He has to think of all these things when he has a child in front of him that's in an altered state of mind. Lead is one of those factors. And I don't understand why there's a big distinction in lead paint cases. We just want to be treated like the other experts in other personal injury matters.
Mr. Nevin,
yes.
You make an alternative argument that if it were appropriate to have excluded Dr. Sundell to testify about the source of the lead, that nonetheless he could have testified appropriately about lead paint poisoning in children generally,
yes.
and that you would have approached the causation requirement either through circumstantial evidence a la Dow, Ross, and Hamilton, or Dr. Simon would have provided the causation or the link. What was the state of the record at the time summary judgment was entered as to any circumstantial evidence as to the source of the lead.
Okay. First off, I believe that's a misstatement of our position. And to the extent that we aren't saying
I
that.
thought it was a verbatim statement
No.
of your
Well,
page
you
14
said.
argument.
Well, you said, Your Honor, and I can look at it again, but our position is that absent the source testimony, Dr. Sundell could still testify as to cause of the medical injuries of the plaintiff. You said general causation, specific causation. He could testify as to that. He's qualified to testify to that. It's what, it's what everything he had. You want to know the factual basis as to that is that the criticism of the Hazelwood court is that he didn't conduct IQ testing. We have a neuropsychologist.
Was arguendo correct as to excluding Dr. Sundell's opinion on source exposure?
Source, what house, where he was exposed.
Okay. Was correct. Let's say that
Right.
it was correct. Exclude him as to that.
Right.
How were you going to prove that otherwise?
Well, we had Dr. Simon in the case. He was a qualified, and Judge Carrion had already ruled that he was qualified to testify that
Did
the
you have any
house.
circumstantial evidence as discussed in Ross
Oh,
and Hamilton?
oh, absolutely. We
What was
had
that?
lead testing in the house. We had the age of the house. We had testimony of flaking and chipping paint in the house. We had the lead levels, which began at the subject property, which also baffled me in the lower Roy decision when they talk about the first property where the client lived, and that wasn't eliminated by Dr. Sundell when there was no blood lead levels at the first house. That wasn't an issue at any point in the lower trial court. For some reason, the Court of Special Appeals threw that in. They had to make some type of Hamilton versus Kearson decision where you set out clearly you had to rule out any reasonable probable causes. Well, that first house wasn't a reasonable probable cause because there were no lead levels there, no testimony of flaking and chipping paint at the first property. So we had we had direct evidence of lead in the house. So that wasn't even an analysis. We had plenty of evidence for a jury to decide that that house was a source of exposure. So the only thing that it left was the testimony of Dr. Sundell and the opinions that the injuries were caused by the exposure to lead. And I don't necessarily submit on the Ross analysis, which I don't oppose it, but what was lost in that case was the fact that the trial court, when they conducted a Fry-Reed hearing, Judge Watts was concerned that the medical expert didn't know how to use an XRF machine. That the medical expert, although they had a report that there was lead in the house, the expert didn't understand what the actual numbers in that report meant. The conclusion was there was lead in the house. That's like saying an internist can't look at an X-ray because they didn't place the person on the X-ray machine. They don't know how the X-ray machine works. They don't know how they get this picture that shows a broken bone. So therefore, they can't testify that there's a broken bone. So that got lost in the Ross decision. So that the Ross decision doesn't stand for no medical expert could ever testify as to the location of the exposure. There may be enough evidence to support that. Why not? If you have a lead test in a house, you have blood lead levels in the house, flaking, chipping paint, young kid, the whole 9 yards, why can't that expert also say, just like that bone was caused by the accident, that the lead levels were caused by that house?
Mr. Nevin, I know you
Yes.
realize you're into your rebuttal, and
Right.
you're free to use it up now if you wish.
I think I'll hold. But what I wanted to bring the court's attention to is just last week in the in State versus Wayne, W-A-I-N-E, this court wrote about stare decisis, and it means to stand by the thing decided, and in the preferred course, because it promotes the even-handed, predictable, and consistent, read from the development of legal principles, fosters reliance on judicial decisions, and contributes to the actual perceived integrity of the judicial system. I've been operating under the law in lead paint cases for 23 years now. I know what it means to be a qualified expert. I understand Radman and what it stands for. Blackwell v. Wyeth did not change that. Also, I was familiar with Dr. Shoemaker in the Chesson decisions, where he was out on his own making his own decisions. This is lead poisoning. This is a pediatrician with 20 years' experience. He's board certified, and this is, in particular, his field. He thinks about it every day. He's qualified to talk about the injuries. Thank you. I'll reserve the rest of my time, please.
All right, very good, Mr. Nevin. Mr., do I pronounce it correctly? Parler?
Yes.
Okay. Good morning.
May it please the Court, William Parler for the Dackman respondents. I'll be addressing the qualifications issue, and my colleague, Ms. Kelly Grafton, will be addressing the standard of review. I think this Court has made clear since 2009 in the Blackwell opinion that when we're talking about complex medical issues and questions, that an expert testifying in that particular realm must have the specialized training, experience, and knowledge to address those issues. With regard to lead litigation is different from other toxic tort litigation. In asbestos cases, you know that malignant mesothelioma is a marker for asbestos exposure. With regard to vinyl chloride, we know that angiosarcoma is a marker for that disease. With regard to benzene claims, we know that various leukemias and blood disorders are a marker for that exposure. However, with regard to lead claims, there is no pattern of cognitive deficits or even any single deficit that is uniquely attributable to lead. There is considerable debate in the medical community and in the published studies and literature about the effects of lead with regard to both the types of associated injuries and the extent of those injuries. Making the issues more complicated is that the claimed injuries due to lead are not easily identified, as there are a whole host and wide range of factors other than lead that may cause or contribute to a person's IQ, or issues with regard to attention, or issues with regard to behavior, or other issues related to cognitive functioning that over the years have been attributed to lead.
Are you saying that the science is not sufficiently settled within the scientific community that lead paint leads to some neurological deficit?
That's exactly what I'm saying, that there continues to be debate in the peer-reviewed publications about the effects of lead, the extent of those effects, and a debate.
I see those as two separate points.
Yes.
One is, does lead cause the deficits? The second point is, do the doctors or other scientists have a way of measuring what those effects are?
Your Honor, there are the answer is that there is a debate on both sides of that particular point. There are certain.
The Center for Disease Control's Center for Disease Control spoken on this very issue?
The Center for Disease Control, it's important to note, is not an expert. It's a committee convened, and
I thought maybe in response to Judge Atkins' question, the debate would be not whether the ingestion of lead can lead to these results, but whether other things can as well.
that is the debate, and we've attached some of the articles on the pointing out, particularly the Bellinger and Stiles and the Huff article and the Samaroff article, that talk about the other potential causes of issues related to cognitive functioning and the relationship between, there have been publications indicating that there are a whole host of factors significantly more important to a developing child.
That goes to what caused the result.
Yes.
But your argument is that there is insufficient scientific evidence that the ingestion of lead can lead to decreases in IQ and behavioral abnormalities? You're saying there is no...
I think there's a healthy debate on that. And with regard to behavior, Dr. Needleman, who's sort of viewed as the grandfather of these studies, you mentioned behavior. He published a study associating behavior due to lead several years ago that, very interestingly, if you look at Table 6 of that study, and unmentioned in the study is the fact that all of the children that had the higher lead levels had significantly higher IQs. So even within the studies of those experts regarded as proponents of the view that lead causes injury or affects IQ in some manner or affects behavior, within those studies, one can pick out inconsistencies, if you will, with regard to the effects of lead.
Now, Dr. Sundell relied upon the Needleman study, did he not?
Well, Your Honor, I think that the history here was that in 2010, he testified that he was approached by Petitioner's Counsel in the Hazelwood case.
That's not what I asked you.
No. And I think that was one of the basic studies he was given along with other expert reports. But I think the debate in the medical community, I think, weighs in terms of deciding who's qualified and who isn't, that you have to have somebody with an in-depth knowledge of the literature, not just one side, but both sides. And you've got to have an understanding of that debate. And with regard to for example...
Do you think we require that depth of knowledge in other areas of the law, not in lead paint cases?
I think it's required, having been involved in other toxic tort cases, I think it's definitely required of experts in other toxic tort cases. Now, there's a whole range of other types of cases. Motor tort case, a dog bite case, does somebody have to have special...
Criminal cases?
Criminal cases.
Police testify as experts?
Yeah, there are probably some cases, motor tort cases, orthopedic cases, where somebody has an MD and they learned in medical school how to fix or place a bone. They're probably qualified, I would say. This is not one of those areas because these issues are complex. These injuries are difficult to identify, and they do require an expert that has far more knowledge, experience, and training than Dr. Sundell presented in this case. His testimony in both this case and in Hazelwood, and I should point out, the hearing before Judge Peters was May 6th of 2013. The Hazelwood opinion was published on March 22nd, 2013.
It was just 10 days or so?
March 22nd to May 6th, within about 45 days.
A month or
40
so.
days. And what we pointed out, and at the record at pages 1146 to 1149, Judge Peters went through and he repeatedly asked Petitioner's Counsel what's different about this record from Hazelwood, and I would respectfully submit a review of that record shows that with regard to relevant qualifications, there was no difference. Dr. Sundell, in our case, as in Hazelwood, had never diagnosed or evaluated a pediatric patient for lead ingestion. He had not published any papers on lead or been involved in any studies on lead. He had not lectured on lead. He testified he's a hospitalist. He does not have a clinical pediatric practice. He's not a toxicologist, epidemiologist, or lead risk assessor. He's never been asked professionally to identify the sources of lead.
What does a lead risk assessor do?
They have training in operating basically an XRF machine, and they also have training.
You wouldn't expect a doctor to do that, would you?
Well, you'd expect a doctor to have knowledge or understanding of the process, and you'd certainly expect, and by the way, it goes beyond an XRF, assessing other environmental risk factors.
Are they the people that go to the house and determine whether there's
Right,
lead?
and they'll sample lead in the soil, lead in the water, and they'll do a full risk assessment. I think it is important that that doctors testifying on medical causation, number one, have experience professionally in identifying source, which Dr. Sundell didn't.
But not that they be certified lead assessors.
Right.
Okay.
Right.
As an advocate here in this case today, Mr. Parler, you're not arguing that the studies and the proponents of the causation of lead translating into impairment in developing children is junk science, are you?
I would never take that position. And
your position is that there's a robust
debate
going on. So why isn't that fit to present to the fact finder?
Well, Your Honor, I think with a qualified expert, that it certainly is a debate. And typically, and I've tried some of these cases and I know Mr. Nevin has, when you have the qualified expert, you present the testimony from both of those experts, and it goes to the jury. But I think it is important given the complexity. I'm not saying it's junk science. There's nobody even on...
Are you even saying it's novel? It's a novel question, whether lead can be a cause?
I can't say it's novel because Dr. Needleman's studies, I think, first came out in the 80s. So it's something that's been looked at by experts for a number of years.
Has it passed the Fry-Reed test?
Yeah.
Well, I think it's past the Fry-Reed test, but
So then, a significant part of the relevant community of scientists say this is okay.
Well, I think...
Even if it's not unanimous.
Let me...
Is that
even on the...
Where are you with this?
On the debate. Well, I'm an attorney. I got a C in organic chemistry, so that's why I'm here as an attorney and not a physician.
No,
but,
I don't mean where your personal opinion is.
Right.
What is your position?
There is no opinion testimony. There is no one out there saying lead is good or lead is healthy. The debate is, and it's a very robust debate as published in the peer-reviewed journals, is what does lead affect? What's the extent of the effect? And how do we devise epidemiological testing to weed out the potential covariates? Poverty, genetics, nutrition, trauma, drug issues. How do we put together a study? And that really is the focus of the debate.
Has anyone tried to do that?
There have been attempts, and that really is where the robust debate is, attempts to identify the injuries and the extent, and then other very well-qualified, well-regarded experts saying, we think there are problems with the test, we think there are other issues that have not been accounted for that have a far greater impact on a young man's or young lady's cognitive functioning than lead.
Don't we use the standard of a substantial contributing
factor? But this robust debate brings me back to you, I think respectfully, must have an expert with specialized knowledge and training. And the problem with having an expert who does not have that training or an understanding of the IQ process or testing, and IQ is one of the three primary components to assess injuries in lead cases, IQ, behavior, and attention, is the testimony of Dr. Sundell quoted in the Hazelwood opinion. And he was asked when questioned as how he arrived at the range of loss of 7 to 10 IQ points, Dr. Sundell testified. So the studies, there are many studies now that show loss of IQ points with lead. I think the exact number of points, there's some variation. So for every additional 10 micrograms per deciliter of elevated blood lead level, the loss of IQ points is somewhere around 1 to 4, 1 to 5, something in that range. So it seems that Appellate's loss of IQ points would be somewhere 7 from the first 10 micrograms per deciliter, and then additional few points above that, potentially even more. I feel I'm potentially being a little conservative, but potentially there's a loss of more than 7 to 10 IQ points. That testimony, identified by the court in Hazelwood, by Judge Watts, is fundamentally incorrect, and he never answered the question, what is the basis?
Now, what about the testimony regarding the land fear study, which he identifies as an international crude analysis from 2005?
Well, Lanphier is one of those experts who has put together in a peer-reviewed publication a study suggesting that the effects of lead on IQ are not dose responsive, which puts it at odds with almost every other toxic torch. In other words,
Are not what?
Dose responsive. His basic premise is that lead levels below 10 have a more significant effect than the lead levels after 10. And the other side of the fence of that argument is that there are a whole host of covariates and variables that have not been accounted for, that Dr. Lanphier has not accounted for, and that call into question the validity of his results, which, if you look at a meta-analysis, a graph of all the studies looking at the effects of lead on IQ, Dr. Lanphier's test results are an outlier. They haven't been matched or confirmed by anybody else if one looks at the meta-analysis on the graph, and that's why they're called into question. Yes, Dr. Sundell was furnished with Dr. Lanphier's studies in 2010, but Dr. Lanphier's studies are now the focal point of this robust debate among experts in the medical community.
But would you say Dr. Lanphier's studies and his methodology have been rejected by a majority of scientists in the field?
I would say that and I'm not aware of any polls. I can tell you that in a meta-analysis looking at graphs of all the studies looking at the effects of lead on IQ, his study, and it's Camfield and Lanphier, with regard to the effects of lead beneath 10 micrograms per deciliter, is unquestionably an outlier. And the robust debate involves whether or not Dr. Lanphier and Dr. Camfield have accounted for all the covariables. Is this legitimate? And I think the consensus is that it requires further and additional study.
Okay, just a couple of things. First, in your response to the court's questions, do we have all that in the record, or are you asking us to take judicial notice of the reaction to the Lanphier study?
I think we've addressed in our brief, and we've attached, actually in the brief, the 3 articles that touch on the debate.
All right, very good. Then you've answered my first question. Now you notice that you're cutting into your colleague's time. You have for the last couple of moments.
Well, yes.
Answering the court's questions, of course, but still.
Yeah, on the qualifications issues, if there are any questions, I'm happy to answer them. But I do think that the quoted testimony of Dr. Sundell in the Hazelwood opinion shows the very real problem of conferring expert status on an expert that does not have a grasp or an understanding on the subject matter. And this court, in the Ross opinion, actually noted the concern about conferring expert status on somebody offering essentially, and in our position, our view of Dr. Sundell is, he's essentially a layperson. You know, I'm sure he's a very good pediatrician. I'm sure he's a good hospitalist. He's not a lead expert. He's essentially a layperson in 2010, brought into the fold by Petitioner's Counsel, given a few studies, and then given a few expert reports to look at, and then designated as an expert.
What do you do with his testimony that he always considers lead paint when he evaluates youth who have come into the hospital presenting whatever symptoms they present?
In terms of the differential diagnosis, Your Honor, respectfully, any parent could say that. I mean, I suppose if your child had a headache or a stomach ache or something, I could say, well, was it something they ate? Was it the cereal they didn't eat? Mentally, I suppose that the lead could be on that list of differential diagnoses. I certainly don't think that confers expert status on Dr. Sindel.
Well, that would be an interesting debate. He does have a professional obligation to be conversant if he's considering it.
He does, and what I think is striking is that he testified in this case and in Hazelwood. He's never diagnosed or treated or encountered anyone with lead other than he participated, presumably with a group, in the chelation therapy of a child sometime between 1980 and 1985 as a resident. Beyond that...
So how common is chelation?
Well, it's very uncommon today. Years ago, it was fairly common if a child had a very elevated lead level. They were given intravenous treatment, usually EDTA. Later, Dr. Chisholm at the Johns Hopkins developed a tablet or a pill that could be taken by the children to reduce their lead levels, and the goal is to bind with the lead metal and then flush the metal through the system.
And is that currently?
It really, I think, in large part because the median or mean population lead levels have declined so dramatically, and largely due to the removal of tetraethyl lead from gasoline, that we really see very, very, very few instances at this point of children that have gone through chelation therapy.
Okay, now, Mr. Parler, I'm going to stop you for a moment. How much time is remaining? I can't discern because the lights have been 10 minutes. 10 minutes on your side of the case.
Yes, Your Honor. Just very briefly, I think that the Hazelwood opinion, where Dr. Sindel was permitted to testify as an expert before the jury and then offered fundamentally incorrect testimony without providing a basis, shows not just that testimony from an expert like Dr. Sindel might confuse a jury. The potential is testimony from somebody who's completely unqualified may potentially mislead the jury. And this court, in the Ross opinion, talked about those concerns about deeming somebody qualified as an expert who shouldn't have been qualified. And this was with regard to Dr. Blackwell White with regard to her source testimony. And the court said, in those circumstances, the qualification of the witness as an expert would endow such an opinion, which otherwise appears difficult to distinguish from a lay opinion, with the imprimatur of court-endorsed expert status. It may be perfectly reasonable to conclude from the evidence that the Payson Street home was a source of lead exposure, but just because a conclusion is reasonable does not mean that a court must permit an expert to make it. The trial judge ought to insist that a proffered expert bring to the jury more than the lawyers can offer an argument. In re air crash disaster at New Orleans, 795 F. 2nd, 1230. Even where an expert may be better able to articulate an explanation, that does not require expertise. The utility of the testimony may be outweighed by the risk that a jury would give the opinion undue weight because it was stated by a court-qualified expert. In such circumstances, a trial court is well within its discretion in concluding that the testimony of the expert would not assist the trier of fact. And what comes to mind is what Judge Wilner brought up during petitioner's argument with regard to Dr. Sindel, in this case, his specific opinions, which include he was going to talk about lead as a source at the defendant's property. That letter went out in February of 2012. Dr. Sindel testified he had not received any records in the case until September of 2012. I would respectfully submit we don't want a situation where we have thoroughly unqualified experts designated in these very complex cases and brought in to simply parrot the arguments or the positions of counsel. And that's what happened with regard to Dr. Sundell in this case, and that's exactly what happened with Dr. Sundell in the Hazelwood case. And respectfully, we'd ask that the lower courts be affirmed with regard to the exclusion of Dr. Sundell. Unless there are any further questions, I'd like to turn the podium over to my colleague.
All right, that's fine. Thank you, Mr. Parler. Ms. Grafton?
Good morning, Your Honors. I would just like to spend a few moments on the standard of review issue brought up in petitioner's brief, because I think that there's an interesting point to be made here. The petition presents the argument that your opinion in Hamilton v. Curzon created a dual standard review based on when an expert is excluded in a case. They argue that if an expert is challenged and that challenge is denied and the expert is allowed to testify at trial, then the decision is reviewed under an abuse of discretion standard. But if the expert is, on the other hand, stricken and summary judgment is entered, then a de novo standard of review should apply. But I think that the difference needs to be not when the expert is excluded, but why the expert is excluded. In Hamilton v. Curzon, the experts were excluded because they lacked a sufficient factual basis under 57023. Here we have an expert who was challenged because he lacked both the qualifications and the factual basis. So in Curzon, the expert was excluded because the facts were not, did not support his opinion, and those same limited facts also could not support a prima facie case of negligence. Therefore, part and parcel, experts excluded, and summary judgment should be entered. Here, arguably, the Court of Special Appeals could have considered the qualifications issue as a judgment call on abuse of discretion standard, and the decision as to whether or not Dr. Sundell could testify based on the facts available to him on a de novo standard. So I think that there could be a different standard of review depending on why an expert was excluded. To be honest, when I got the petition, I couldn't quite figure out what it was that petitioner was asking for, because it seemed like they were asking for an abuse of discretion standard in a case where they lost at the lower court. It became evident in the brief that what they were asking for, in fact, was an abuse of discretion standard to be applied to an interlocutory opinion, an order that came down from Judge Carrion in this case before the issuance of Hazelwood, before the issuance of Ross, and that was later overturned by Judge Peters. And we would just like to make the point that you certainly cannot have a deferential review of an order in a case that's preliminary, that's been overturned, that's been vacated by a later order that resulted in final judgment of the case. There is no case, no rule of law that says that Judge Peters had to defer to Judge Carrion's ruling, especially when there had been a very recent change in the law and circumstances. Ross and Hazelwood came down, I believe, 3 days after Judge Carrion issued her opinion saying that Sundell was qualified.
Now, could you review procedurally, how did the case get from Judge Carrion to Judge Peters?
Certainly. We filed a motion to exclude in combination with a motion for summary judgment that was heard by Judge Carrion. This was before the Ross opinion came down and before the Hazelwood opinion was published. Judge Carrion conducted a review of the case file and determined that Dr. Sundell was qualified and should testify, and summary judgment was not appropriate at that time.
Okay.
Couple, I believe 3 days later, we get the published Hazelwood opinion, the Ross opinions, and we present a renewed motion for summary judgment. Now, there was some question in petitioner's brief whether we were judge shopping, I believe was the term used there, because we filed a renewed motion as opposed to a motion to reconsider. But Judge Peters considered that issue and said, I believe his quote was, "We were probably right because we could have done it either way." And in our reading of the rules, Rule 2602A3 says that an order of decision that adjudicates fewer than all of the issues can be modified at any time. And cases for the last 2 decades have said that motions for summary judgment can be renewed and filed at any time. So we took that route. Seemed like a 50-50 call. We went with a renewed motion for summary judgment, given that there was new case law to be evaluated. We presented a new motion based on the analysis of Judge Watts in Hazelwood, and we discussed the analysis from this court in Ross. That was presented to Judge Peters. He had the benefit of our motion, an opposition to that motion, a reply memorandum, a supplemental opposition, a new affidavit from Dr. Sundell presented by Petitioner's Counsel that outlined what they believed to be responses to all of the criticisms in the Hazelwood case, and the additional benefit of Dr. Sundell's deposition in this case. After reviewing all of that information, all of these new arguments based on the evolving case law that had come down from both this court and the Court of Special Appeals, Judge Peters found that Dr. Sundell was not qualified, and that summary judgment was appropriate because there were not sufficient facts to support presenting this case to the fact finder.
And he did it in his discretion, he said.
Yes. Yes. He did not have any obligation to adopt the opinion of Judge Carey, and he looked at everything fresh and new and decided that Dr. Sundell was not qualified and that summary judgment was appropriate. There is no cause for the Court of Special Appeals or this court to give some deference of some variety to Judge Carey's prior order that was vacated.
Is your position essentially that the last in time is the ruling that we look at?
Yes, because
Judge Peters as opposed to what Judge Carey did for whatever reason? Mm-hmm.
Because Judge Peters created the final judgment in this case, he essentially overturned what Judge Carey did, and there's no case law that I could find that says that Judge Peters couldn't do exactly what he did. The prior decision from Judge Carey is an interlocutory order that's not final until the case itself is final.
And to what standard do we apply to Judge Peters' decision? I think I know your answer. But.
Well, again, I think it's an interesting point. I think it turns on why the expert was excluded, and I think we would advocate for a dual approach here, that when an expert is excluded on factual basis grounds, and I see my time is
Just
up.
to complete your sentence, if you will. And
Thank you. When an expert is excluded on factual basis grounds, then it could be considered a de novo standard of review because it's a legal decision whether the facts available support the expert's
here it was
opinion.
both, and so as to both.
Absolutely, because the same facts that were not available to the expert are also not available to the jury to find that there's a case of negligence.
All right, very good. Thank you, Ms. Grafton. Mr. Nevin.
How much time do I have, please? How much?
10 minutes. Thank you.
Addressing the last issue, I beg this court, please look at the renewed motion. It purely said because of Hazelwood, Dr. Sundell is not qualified. Look at the argument, the hearing that's been presented with Judge Peters. I was going through and talking about the affidavit and his deposition testimony, all the additional information that was in the record. And that's important because the record is important. Because the one thing we do get out of Hazelwood is the comment that it was a review of the record. And I direct your attention to 887 and 886, where the court at least probably 10 times says, based on review of the record, they say it on 887 in the left-hand column. Again, on page 888, from the record in Dr. Simon's testimony. And then again, the record fails to substantiate Dr. Sundell's possessed specialized knowledge.
887?
E887 in volume 2 of the record extract. Okay. And again, he says, because the record demonstrates. And I'm just saying it's important.
That's the case. 887 is a case. I assume
No, that is the Hazelwood decision.
Okay.
Okay? But in the Hazelwood decision, the court was saying that she was looking at the record. Okay? That's very important because also at the top right-hand column, the top left-hand column of 888, significant, though, during the deposition, when asked for the names of the articles he had read or reviewed concerning lead poisoning, Dr. Sundell was unable to recall any names of the articles. What the court totally overlooked, for one reason or another, is that he testified at trial. There was voir dire. And during the voir dire, we're talking about the Center for Disease Control. We're talking about the Environmental Protection Agency. We're talking about Canfield, Lanphier, and the other studies on childhood lead poisoning. That what do they generally show? That they all say a loss of IQ points. They all say, the published articles from the EPA says that houses are predominantly the source of lead poisoning for children after the 1990s, 91 and so. So this is what he testified to, and yet the court in Hazelwood is looking at his deposition testimony?
Mr. Nevin, I'm confused right here. Because I thought you were addressing the second argument
Okay,
that was
yes.
raised.
I'm sorry, I did get
And
distracted.
I know you've gone on
But-
Hazelwood.
But it goes to, again, the fact that, there was no deference paid to Judge Carrion's full analysis of the facts. That just 3 days after the opinion came out, they filed a renewed
But
motion.
didn't Judge Peters read the deposition in the case?
He might have said he did. To be honest with you, he didn't quote anything
he
from
said
it.
he did.
He said he did. He said he reviewed the materials. But the thing that Judge
And
Peters
he
did...
said that he was exercising his discretion.
Yeah, and when you look at that, though, what he was looking for me to say is that since Hazelwood, Dr. Sundell had evaluated and treated a child for lead. And that wasn't the case.
Sure.
Okay? What does it mean, though, to evaluate, as Mr. Parler has been saying to you? There is no treatment for childhood lead poisoning other than chelation, which we really don't see anymore, thank goodness. It's following, it's testing children, it's giving education. That's the extent of the treatment. And it wasn't there, but that is inconsistent with the law as far as it being necessary for them, because I believe 5702 is still the law that in making a determination, the court shall determine whether the witness is qualified as expert by knowledge, skill, experience, training, or education. Any one of those can be enough. And he abused his discretion because he was just limited by the Hazelwood decision when he didn't really consider in total the record before him and really evaluate the fact in light. Now, going on to the other...
So it isn't an issue of deference, then? Yeah, okay.
I'm sorry?
That's why I'm
sure.
getting lost here.
Because
as I understand it, just procedurally in Baltimore City, there's motions practice, and then the case will land with a trial
Right.
judge. And it's my understanding from years of practice, having done that in Baltimore City, that oftentimes the judges may disagree. There's no law of the case per se, and there's a re-look at it. And so I thought your argument was that unlike the practice that's been going on for years, really circuit court judges should give deference to one another. But your argument has changed then, because now you're saying that he didn't consider the record.
Okay. Well, I mean, it's both. I mean, there was plenty of record in front of him because after the Hazelwood decision, Dr. Sundell was deposed before Judge Peters.
So what's this issue of deference?
Well,
what are you saying about a circuit court judge anywhere deferring to the ruling on a motion by another circuit court judge?
I think in this particular case, where a motion was filed and then a law came in, it should have been sent back to Judge Carrion for her reconsideration. He at no time did
Why?
Because otherwise you are, frankly, I believe, judge shopping.
Why
And
are
you're
you judge
encouraging
shopping?
judge shopping, huh?
Why are you judge shopping?
Well, leave that be, okay, whatever.
Because
With this
the
court,
motion was a renewed, with a new motion,
it was a new motion.
filed with the clerk.
Right.
How did it get to Judge Peters?
Just through the normal course of...
So it wasn't the defendant that took it to Judge Peters' chambers?
No, Your Honor, I'm not trying to say
And
that
how
at
is
all.
it judge shopping?
Well, I believe that because I believe I had responded that this is a matter that needs to go before Judge Carrion. But anyhow, I'd like to just address some of the issues that...
Let me ask this question.
Yes.
Suppose, and I know this is not, at least arguably, the case here. Let us suppose you got the same expert, Sundell, and out comes the Court of Special Appeals with an opinion saying, based on all of this, he's not qualified.
Right.
Let us suppose that he learned, nothing happened to enhance his knowledge, his experience, anything. Zero. Exactly the same as it was in Hazel, whatever.
No, Your Honor, I disagree with you.
Would a judge be okay in saying, well, the Court of Special Appeals said based on exactly what's before me, he's not qualified?
But what the Court of Special Appeals said, what the record was before it. When you're looking at qualifications, you have to go. What's in the record?
I thought the argument here was, and maybe I just read it wrong, was that he had some other knowledge that he didn't have in Hazelwood.
No, that's not correct.
That's not correct?
That's not correct.
Okay.
The
So
thing
it
is
the
that
same.
what clearly the message was in the Hazelwood decision is that it was based on what the record was as that court interpreted it, okay? So wouldn't it be my duty to make a better record of really what Dr. Sundell's understanding and knowledge of the law? And that's exactly what I did. She said there wasn't enough to say that he talked about the literature.
So you're saying the record is different in this case?
The record is different, and I've been saying that. We have a 14-page affidavit. We have a deposition testimony where he goes, he
So
talks
Judge
about the
Peters
literature.
concluded that it wasn't different enough.
I'm sorry?
Is what we have here before us Judge Peters' conclusion that the record here is not different enough?
He ruled that
Because he relied on Hazelwood.
He relied on Hazelwood. And he was asking me, did he ever treat a child? And the answer to that was no. I mean, that was towards the end, because I kept on going through what is in the record that's different. And this court has to, I believe it's going to say that a determination of qualifications has to be based on what's on the record. The Hazelwood decision did not say Dr. Sundell will never be qualified as a pediatrician in his life, did it? I don't think so. So, that's what the basis of this broad-based or robust argument or debate over lead is made up. It's a defense argument. There is no cites. I looked in his respondent's brief. There's no cases, studies in here. There's no robust argument. The EPA issued a statement in June of 2013 called the Integrated Science Assessment. And I apologize, we didn't attach it because I didn't think it'd be an issue. But in there, they go through that lead causes. It's the first entity that now says lead causes loss of IQ, behavior problems, even attention deficit disorder, and other types of neurocognitive deficits.
What's the name
And
of the
based
study?
that on the wealth of literature.
What's the name of the study?
It's called the Environmental Protection Agency Integrated Science Assessment, ISA for short. It's an 1,800-page document, but there's about 133 pages about the effects of lead. And if you look at ES1, chart ES1, Your Honor, is a chart where they lay out, first they talk about how they came to this conclusion.
All right, Mr. Nevin, you've given us the information that we need.
Okay, thank you.
I just want to mention that on page 28, I had obviously read the respondent's brief.
Mm-hmm.
There are references to journals in here on
Right.
page 28 of the brief, and I just wanted to mention that to you because I remember
Well,
reading
Well,
that.
we
I
will
thought he
look-
said he attached them.
Mr. Nevin, your time is exhausted, and yes, we have to stick
I
to,
understand.
yes, be fair to both sides. All right, thank you very much, counsel, in the case, and we will pause for just a moment, but if counsel in the next case, looks like next is May individually and executrix of the estate of May versus Air Liquid Systems. Did I skip a case? Oh, excuse me, I'm sorry. Yes, things got a little bit out of order here. I am next calling the AGC case. You'll have just a few more moments to relax, counsel. This is AGC versus Young.
Don't step out for too long.
Don't step out for too long.